Hi, and welcome to Hull & Hull TV. I'm Suzana Popovic-Montag, the managing partner of Hull & Hull, a firm specializing in estate, trust, and capacity litigation. I'm very pleased to be joined today by our co-founding partner, Ian Hull, and counsel to our firm, David Freedman. David is also a professor at Queen's University, and so we're very pleased to have him join us today. Ian, we hear so much in the media these days about this concept of elder law. What exactly is elder law?
Well, I think it's an excellent starting point to what is going to be a fun episode, because what we have, we're very lucky today to have David on a bunch of levels. But first of all, he is the director of the Elder Law Clinic at Queen's, and currently runs a very active LinkedIn posting through the Canadian Estates and Trust Litigation Council. So I'm going to, with the help of Suzana, put you on the spot a little bit, and that is in large part because you're a Habs fan. But
as close as I come to religion.
Well, and so we're going to make sure that you're peppered with the shots that would be typically shot by Van Riemsdyk or the others from our side of the equation. But let's focus on the elder law question and what is elder law and where are we going with it, certainly in Canada, and what are you seeing really on the front lines at your elder law clinic?
Okay, so elder law is it's a new area of practice. It's not a new area of law like contracts law or wills and estates law. And it reflects the changes that are going on in society. You know, people are living much longer lives. There are more people 85 years in age now alive in Canada than ever has been the case. And with an aging population comes new kinds of legal issues. And with changes in society comes new kinds of legal issues. So I have a lot of older people that are not necessarily as well linked into family as they have been in the past. But there are care issues, there are issues about capacity, exploitation, vulnerability, and that's what elder law is about. It really, if you want to give it a short form, it's allowing older people to live in dignity and to protect their rights and not treat them as children, but have the law speak to what their issues are. And so we have an elder law clinic at Queen's University that I started a few years ago, and we mainly help indigent older adults. With wills, with powers of attorney, sometimes with age-related discrimination, and allow them to live lives in dignity. And the law is developing, and I have to say that the students at Queen's Law are really interested and really responsive. It's the first law school elder law clinic of its kind in Canada. There is a legal aid clinic in Toronto, but very successful. And I think it's something that lawyers in our area of law are going to have to be increasingly sensitive to.
You know, and that's a fascinating, and kudos to you for stepping into the clinic side of the work, because where Suzanne and I practice in the elder law sphere is typically in contentious battles over who's going to charge of what is maybe a parent who's in the gray area of capacity. And typically, unfortunately, it's driven by money. Right. And it's not driven by what is, and we don't see a lot of dignity in some of this litigation. Right. And we don't see a lot of the kinds of issues that really need to come to the forefront when we're dealing with the elder law issues, because at the end of the day, you're right, it's independence and dignity that we need to give all spheres of our society the right to.
Yeah, I think oftentimes wills and estates practitioners will become involved in power of attorney disputes, where someone is misusing a power of attorney and is exploiting a vulnerable person. And that happens at a lower level too. You know, it's just as important when it happens in respect of a welfare check or a pension check as well, you know, assets of, you know, $100,000, or where people are ignored and neglected. And so, you know, certainly it's part of a conventional practice, but I think that part of the issues that are arising are that not everyone has access to you, you know, and they may not have access to any lawyers, and that's the problem.
And Ian, David mentioned powers of attorney. What is the difference between a power of attorney for property and a power of attorney for personal care?
Well, I think it's such a vital distinction, and power of attorney for property is what we conventionally would understand to be a document for which we've created that gives someone else the authority to deal with your finances and your assets. And I always remind my clients that it's a blank check. once you've signed it, unless you have restrictions on it, springing powers of attorney and some of the more complex arrangements with power of attorney, but the conventional 99% of our clients do is a solid, clean power of attorney handing over authority to someone else to look after any and all of their finances without restriction. The power of attorney for personal care, on the other hand, is a similar release of control over to someone else, but for personal care decisions.
And only when they're incapable.
That's right.
And so there's a huge difference there. And I just want to pick up on one point that Ian said. A lot of people make these power of attorney documents, and they use forms that are made available by the Ministry of the Attorney General online that don't really explain to people how to make them. And they often make powers of attorney for property management with immediate effect and don't realize that they're doing so. These are not necessarily documents that only come into existence on incapacity. And so they can be very dangerous things if they're not drawn correctly.
Yeah, and I think that's so crucial, the fact that with financial powers of attorney, as opposed to the personal care, when they are open-ended and they're open and active when signed. But there's also they're a vital document for both the elderly, but for everyone. And I was out last night and riding one of my friends whose kid just turned 18. I said, get him a power of attorney. And wills maybe not quite as important at that stage in life where you don't, but you do not want to have a situation where, God forbid, something happens when these kids are in their most active stages between 18 and 30, where they are going to get themselves possibly in a situation where they get into a head injury or something. And that power of attorney can obviously transformatively resolve a lot of issues for the parent as well. And it's a funny thing that most people don't think of it even at that stage, but it's a powerful tool for planning across the ages.
It's a very good point, Ian. Thank you. And David, thank you for the commendable and very worthy work that you do through the Elder Law Clinic.
Thank you.
And thank you for joining us here at Hull & Hull TV.